Good morning and welcome to today's webinar presentation, The Essentials of Estate Planning and Elder Law, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's presentation. So again, welcome to those that are new to our educational webinar series and also to those that are frequent attendees. And we always encourage your general questions, so please note them in the questions panel on your screen. And as always, we'll pause periodically throughout the presentation to address them. Your questions are welcome and really help the presentation and add value. They help others learn, so don't be shy in posing your questions at any time. You also received the presentation slides by email from me yesterday to take notes on them if you wish. These materials are also available in the section marked handouts in the panel on your screen to download at this time. Everyone will also receive a post-webinar feedback email right after the presentation, and we value your feedback, so please take a few minutes to fill out this very brief and simple survey to give us your thoughts about today's presentation, and we read and value every comment that you have to share with us. Here at Elville & Associates, we want to be a resource to you for your families and your planning needs. If you have planning that needs to be addressed, old documents that may need to be revisited, which is not out of the ordinary, or perhaps another matter, consider today's presentation and information as a jumping off point to get your planning started. Consultations are the most ideal way to get your specific questions answered by Steve, have him understand your individual situation and help create solutions and a path forward for you. So I'd like to offer Steve and the firm a proper introduction before we get started. We have a quick poll to learn who's joined us today, and then we will dive into the presentation. We have a lot to cover today. So you should be able to see my screen here. Here at Elville & Associates, we were founded in 2010 in Columbia by Stephen Elville. We have several different practice areas that we focus on here at the firm on a daily basis. We're very busy here and blessed to be busy. We focus on estate planning and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations. And our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And Steve and I are coming to you live from the Columbia Gateway Community location today. We also focus on education in several ways here at Elville & Associates on a daily basis. And we do that through our planning processes with our clients. We offer over 100 educational webinars and workshops in the communities that we serve each year. And it's great to do webinars, but we're also getting out and doing several workshops on a continual basis each month, which is great to do. And also by way of our accredited client care program, we're one of only 2 firms in Maryland to have an accredited CCP, as we call it here, accredited by the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville & Associates. A little bit about Steve. His work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many different national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading technical knowledge. A very seasoned speaker, if you haven't heard Steve present before, presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events on a yearly basis. Steve was also named to the Maryland Super Lawyers list for an 8th time in 2023 and a 7th consecutive year. So congratulations there, Steve. He also had a written feature story about him in the National Super Lawyers magazine about our firm's charity, the Elville Center for the Creative Arts, which he founded in 2014. I'm very privileged to be the executive director of. So if you'd like to learn how we work to make a musical difference in the lives of children each day, I would love to share our story with you, so please feel free to reach out to me. But we have a little bit more to talk about today other than the charity, which is estate planning and elder law. And Steve's going to dive into that presentation in just a moment. on what I think might be the day before his birthday, I hear.
Don't say that, Jeff.
So a happy birthday to Steve.
Thank you, Jeff.
We'll do a virtual happy birthday singing to Steve here. But right now we'll launch into our poll here. And our poll is, what brings you to today's webinar? I'm going to launch that poll. And your choices are pretty simple. The first is, I'm new to estate planning and I need to get started. Second, I have a plan in place but is outdated and needs to be revisited. Third, I feel my plan is on solid ground, but education is always great. Very true statement. And lastly, I'm an advisor here to learn to better serve my clients. So welcome one and all. We appreciate you being here. You have a lot of choices on where you want to be on a Friday morning. Thanks for choosing to be here with us. I always know it's Steve's birthday because he shares a birthday with my youngest daughter, who turns 14 tomorrow. Okay, we'll give it another couple seconds here. And Steve, we have a varied group today. We have 26% say I'm new to estate planning and need to get started. Another 26% say I have a plan in place, but it is outdated. Another 33% say I feel my plan is on solid ground, but education is always great. And 14%, I'm an advisor here to learn to better serve my clients. So welcome, whatever brings you here today. Steve, I'm going to go ahead and make you the presenter.
Thank you so much, Jeff.
Okay.
All right, I'm going to take over the screen, get my slideshow going, and get my technology going. And Jeff, you should be able to see my slideshow.
Looks good.
Very good. Thank you so much. And good morning, everyone. Jeff, thank you so much for all your kind words. And I appreciate everyone who's on this webinar this morning. It's a beautiful month of July. Here we are at the end already. You could be anywhere this morning, as Jeff said, but you're choosing to spend your time with us, and we really appreciate it. Without you, we could not do what we do, which is educate people and their families about estate planning and similar topics. What I want to do this morning, and again, I'm very privileged to lead Elville and Associates and kind of be the face of the firm for all of our attorneys and staff. We are committed to education. We are committed to planning that works. And I realize there's many people on the call this morning, the Zoom call this here, that we have planning in place, or we're thinking about changing our planning, or we have no planning at all. And thank you to our advisor colleagues who are on this webinar as well. My job, as I see it, every time we put on this workshop, is to really lay the groundwork. No matter how many times we've heard it, to revisit it, to juxtapose ideas, to really look at the differences and the nuances in what makes planning work, what is planning all about, what is elder law about, what are the tax topics briefly that are out there right now, and to really lay the groundwork for moving forward wherever you may be. And for those of you who are just here for the continuing education, that is very important too, not only for yourselves, but for your fiduciaries and family members. So as I'd like to say, no matter what you're here for this morning, you are in the right place if you want to be educated. You are in the right place if you want to make sure that your planning works. You're in the right place if you want to learn how to collaboratively have an estate planning team that can help you move forward. So with that said, happy summer to everyone. I know vacations are happening. August is going to be a big month for many of you. So again, welcome. Thank you for your support and for being here today. All right, Jeff, I'm going to advance my slides. Of course, we are meeting virtually here. This is not an attorney-client relationship, but what you're going to see at the end of this presentation is when you do consult with an attorney about estate planning or elder law or special needs planning or other issues, you are creating an attorney-client relationship at that time, and there's nothing to fear about that. But here on the virtual presentation this morning, of course, this can't be construed as legal advice, but we are going to try to be as very high level as we can with our answers. I want you to ask questions that may come up. Jeff is an expert moderator and he will field your questions. I will stop at certain times and we will do our very best to provide general answers and educational substantive answers about things that may be on your mind. All right, let's get started. We're going to talk about what estate planning actually is, and we're going to talk about something that's important, which is a process of estate planning. Process is hugely important, and we're going to talk about that. We're going to talk about why estate plans sometimes don't work the way they're supposed to, and what can we do to avoid that. We're going to talk about wills versus trusts. These are the fundamental questions that most Americans have about estate planning at the outset. And I guess the background idea there is really probate versus non-probate concepts. So we're going to talk about that. And I realize that many of you on this webinar this morning have experienced things like this, understanding what probate is and what it isn't. But again, we're going to circle back to the ground level on this. We're going to talk about elder law, taxation, and estate asset protection planning. And what is all that about? I met with a young lawyer yesterday, and he is in a mentorship program. And his first question to me really was, what is the difference between estate planning and elder law? And we're going to talk about that because that's a kind of a ambiguous thing. And we're going to talk about getting started in planning or getting started to revisit our planning and how to work with advisors and collaborative team members. We're going to talk about all of that important stuff about next steps. So let's talk about estate planning and process. So people plan for various reasons. We're living in a very complex world. We're living in a dynamic environment. We're living in a 24-hour news cycle, and it's just a proliferation of information. You're going to have your own reasons, your own emotional and non-emotional reasons for doing planning. No one's family is the same, although sometimes certain family dynamics are somewhat similar. No family is the same. Children have certain issues. If you have children, how you look at nieces and nephews and grandchildren and what your goals are going to be very personal to you. So we're going to talk about some of the reasons people plan, and we're going to talk about why sometimes estate planning does not work the way we want it to and how to avoid that. And we have a whole library, by the way, of webinars. Some of those webinars have to deal with achieving perfection or striving for perfection in estate planning. So those resources are available to you as well. But here today, we're going to, again, drill down into fundamentals. So I want you to think about a purpose or a goal. All planning is goal-driven, G-O-A-L, goal-driven. I want you to have a purpose. I want you to think about this, all of what your life and experience represent, all of what your family dynamics represents. And I want you to think about what is driving me? Why am I here today? What is the thing I want to take away from this that would give me something substantive to hang on to or help me move forward? And maybe you know your goal or maybe you don't know it. So what we're going to talk about today is using a process as a tool, to either fine-tune our goal or to find out what our goal is. Again, I want you to have a purpose. All planning is goal-driven, whether it's tax planning, charitable planning, conventional estate planning, retirement plan, asset planning, whatever it may be, it needs to be goal-driven. Some people plan for certainty for loved ones, and this is probably the most important thing. Some people want smooth administration. They want the assurance that they are laying the groundwork now during life. I spoke to a wonderful client this morning who is laying the groundwork for a loved one who has disabilities. And she's doing it well in advance, not only in her estate planning, but she's doing it for that person's physical well-being, where they live and so forth. So some people want to get things in order in advance for smooth administration. This may involve minimizing costs. This may involve asset protection for a spouse, a niece or nephew, or a beneficiary who is at risk, like even a sibling. or many times children and grandchildren. Some people are focused on taxes. They're focused on the elimination of taxes. Not everybody is, but most people are. And of course, estate planning and one of the goals of many people is to minimize or eliminate taxes. These could be income taxes, estate taxes, gift taxes, generation skipping taxes, inheritance taxes, and so forth. Many people have special things they want to accomplish, like charitable giving, or split gifts between children and nieces and nephews and charities. So you're going to know what this is as you allow yourself time to think. One of the things Jeff and I really talked about, and many of our attorneys and I agreed upon, was at the beginning of COVID, where the world changed, we wanted to commit to giving people time to think. This is where you can really hone your ideas about what your goals are. Now, let's talk about something that's negative. I sometimes use negative examples to illustrate things. I want you to think in terms of why do some estate plans not work the way they're supposed to? Well, you're going to see here in the next 2 or 3 slides that one of the main reasons estate plans don't work is people simply don't do their planning the right way from the outset. They treat their planning as a transaction. Now, is that the average person's fault? And the answer is probably not, because the world, the way it is, the way the legal community is, the way estate planning usually works, it's very transactional. If we can step away from that transactional process, and what do I mean by that? Well, here is a set of documents, this stack of documents, this will, this trust, this power of attorney, this advance directive. This is your estate plan. Well, that is true in one sense, but it's also fatal in another sense, because if I take that stack of documents and I put that in a safe or in the top of my closet, or I put it in a fireproof safe or bag or in a safe deposit box, and I never look at it again for how many years? Well, on average, it's about 19 or 20 years between visits. Some of this is a life cycle. Some of this has to do with many of us are, we become adults, we have children, we live our lives, the children grow up, and then we start thinking about our estate planning again. And this drives the 20-year statistic that most people do not revisit their estate planning for about 19 or 20 years at a time. But if we can step away from that at some point, earlier the better, now we have a chance to make sure that our estate plan will actually work. And that means getting into a process-driven system rather than just a transactional system. So before I go to the next slide, let's just put this in perspective a little bit more. The average person does not have estate planning. This is the majority of people. 55 to 60% roughly of people in this country have no estate planning. So the minority of people actually have planning. Let's just call it about 45%. And then of those people who actually do the responsible thing or the right thing of having planning, only a certain amount of those people actually take it seriously enough to revisit it. And we want to be in that group. We want you to be in that group. And of course, we want to expand this statistic. This is horrible that most people don't have the proper planning. So by getting into a process-driven system, you will be able to be in a partnership relationship with a law firm of your choice that actually provides this path forward. So to reiterate this just a little bit more, I want you to think in terms of 2 major types of estate planning, and I'm talking about at a very fundamental level. Traditional estate planning, which is what I would call a document-driven transactional process. But the other choice, and this is where I want you to be thinking in this webinar, is if I enter into this partnership relationship, if I take the time to think, if I allow myself to be in this partnership, now I can have a process-driven plan where education is the focus. The education of my children or nieces and nephews or fiduciaries is the focus, where I have a collaborative team is the focus. You see, this is a quite different thing than thinking in terms of just a stack of documents that goes into my safe. So we want you to just take away from these last couple of slides that idea. So the traditional plan, again, there's typically no education, there's no process, there's no maintenance and updating, which is not something that most people would find pleasant, but it's absolutely necessary to make sure your planning works the way you want. And of course, there's no follow-up. So we don't want that. We want to avoid that, okay? We want some kind of a process, and it doesn't have to be this particular one. But what I'm illustrating is a multi-step process, a process of information gathering and design and education, and then implementation. That's the first phase. And then the second phase would be maintenance and updating. This is making sure that we're revisiting the estate plan over the years, because do the laws change? Yes. Does the country change? Does the environment change, the political environment? Do the tax laws change? Do the asset protection laws change? For example, retirement plans and the rules and regulations regarding them have changed since 2020. All of these, people's lives change, people's health change, your fiduciaries' lives change. So maintenance and updating is critical over the years. And then if we do all of that, we're going to have an estate plan that has a very high probability of success, and our administration of our estate and all of those goals that we had, whatever they may be, smooth administration, protection of loved ones, all of those things will work the way they're supposed to. This slide right here is really just for your benefit. It just reiterates what I just said about the emphasis on education. We call this the caring for clients model versus the transactional model. This is where we want you to be. This is where we want to be with you in that kind of partnership. Let's now define what estate planning really is. Well, again, you're going to have your own definition of estate planning, and I encourage you to take your tablet or take your pad of paper and whatever it is that you have in front of you, and I want you to think about this. I'm going to give you a very, very simple definition, and you can expand on it from there. And I would recommend you take 60 to 90 seconds to do so. Estate planning, in my view, is about disposing of your property or your assets, meaning giving them at your death the way you want to the persons or organizations of your choice at the lowest possible cost. So let's go over that again. Estate planning, arguably, is about disposing of your assets the way you want to persons or organizations of your choice at the lowest possible cost. And of course, there's going to be this goal-driven activity on your part, your ideas, your goals and values, and how you want to express yourself. So that simple analysis could be expanded on. It could be that you're going to dispose of your property during lifetime. You're going to give gifts, or that maybe you're going to have a more complex plan that provides for certain types of planning. But at its fundamental core, I want you to look at this definition as something you can develop from a basic premise. All right, so having set the stage for how I want you to think about estate planning in the way that we know actually works through the partnership process and through the process-driven process, I want you to now look at the fundamentals of wills versus trusts. So many of you on this webinar today have wills, many of you have trusts, but those of you who have not done estate planning, you may not have either of these documents. You may have a power of attorney document, you may not. We're just going to work through this process now. So the probate process actually involves a will. Remember that a will, or a last will and testament, is by its very nature subject to probate. Now, some states have more onerous probate processes than others, or more elaborate processes. Maryland's process is pretty elaborate versus Virginia's, which I understand is less elaborate or less robust and easier. But when we think about a will, we want to think about what does that will control. So let's talk about what goes through probate. A good example of what actually goes through probate would be an account or property that has no joint owner, and no beneficiary. So let's say that I have a bank account, it has no joint owner, and it has no payable on death beneficiary. Now that bank account is going to go through probate. Probate is what? The process of proving a will to be valid. Probate is the process of proving a will to be valid. Now, having said that, is it possible to have probate without a will? And the answer is yes. Let's say that I die with no will and I have that same account, and that account has $100,000 in it, and that account has no joint owner and no beneficiary. That is still going to go through probate. The will would have directed where that money goes to my beneficiaries and loved ones. But now, in my second example, there is no will. So the laws of intestacy, the laws of Maryland will take over. And now, depending on my marital status, depending on whether I have children, the law is going to dictate where that $100,000 goes. So we want to be in control of our affairs. We don't want the laws of intestacy to take over 95% of the time. So as we look at this slide, basically the probate process controls what? Assets that have no joint owner, no beneficiary. Does an IRA go through probate? No, so long as it has a beneficiary. What if it doesn't have a beneficiary? Then it's very likely going to go through probate and all tax will be due basically at once. So that's a bad thing. We want to avoid that. Does life insurance go through probate? Not if it has a beneficiary, okay? So we just want to understand what goes through probate and what does not. Now, the probate process will vary depending on the family situation, the size of the estate. This is an example of a traditional probate estate. The estate has to be open, there has to be an inventory, there are claims of creditor, period, from the date of death. There's an administration account that's due, and there are many, many other nuances that happen here about time frames and deadlines. The cost of probate is around 4% in Maryland, not because of any statistics that I'm creating, but just because of the fees that are allowable in probate are around 4%. But in some other states, such as New York, North Carolina, other states, the cost of probate can be higher than this. So let's look at what a will structure is. So here we're illustrating a basic estate plan. For those of you who have seen this before, you know what I'm saying. For those of you who haven't seen this, let me explain. Here, the will is the driving force. The will talks about who gets my tangible property, who gets specific gifts, who gets the balance of my estate. If you're married, your spouse will get your property in a certain way. If you're not married, this is going to go down to children or nieces or nephews or others. And that's what this will is dictating. It's controlling that. Now, the will is what happens at death. But if we look at the ancillary documents here, the powers of attorney, the advanced medical directives, which we're going to talk about a little bit later, those have to do with what? Lifetime. Those have to do with incapacity planning. So here we're taking care of two major things. What happens at death with the will, what happens during life with the powers of attorney and advanced directives. Why is what happens during life so important? Because people are living a long time, that's for sure. But why are they really important? Well, they're really important because they provide for your personal instructions about how much flexibility, how much decision making will you empower someone else to take on your behalf. You are the principal and they are the agent. So here you get to decide what the future holds if you ever become incapacitated. And just to set the stage for later discussion of powers of attorney, I will argue that, and many other estate planning attorneys will argue, that of all the documents, of course they're all important, but of all the documents, especially in a will-based plan, powers of attorney are the most important of all the documents. This is the legal side of things, Of course, the advance directives are important and the wills are important as well. Now, an alternative to a will-based plan is a revocable trust-based plan. So many of you on this webinar have a revocable trust. The first thing I want to ask you is your trust funded properly? Have you properly situated your assets in the trust, your non-retirement assets, and are your retirement assets and other life insurance and other basic assets, are they structured properly with beneficiary designations and so forth? So I know some of you on the webinar have these instruments. I just want to challenge you from the beginning to think about this first bullet point. The primary purpose of a revocable trust is to avoid probate. So it is a probate avoidance tool. Let's take a look at a revocable trust, and I'm going to come back to this slide. So just to illustrate this, for those of you on this webinar who have not seen this, remember when we are talking about basic estate planning, a will plan versus a revocable trust plan are our two basic choices. Either one of these structures is going to drive down our assets to our family members, our loved ones, our beneficiaries in the way that we want, okay? The difference is that the revocable trust plan is a plan that avoids probate, but it only avoids the probate process if it is properly funded or aligned with assets. So a revocable trust is an alternative to a will. It's nothing complicated. It has two steps: the creation of the trust itself, and then the alignment or funding of the assets in and around the trust. So it's a private document. It has to be developed and implemented and funded. So it has those two steps. But let's talk about what a revocable trust is not. Well, it is not for asset protection. If I have a revocable trust and I fund that trust with all of my non-retirement assets, I will have no protection from the claims of creditors any more or any less than I had prior to creating the revocable trust. So it is not an asset protection vehicle. Now, with that said, with wills and trusts, can I create asset protection for someone else at my death? Yes, I can create asset protection at my death through further trusts, but the revocable living trust is kind of the simplest of all trusts. It's an alternative to a will, that's all it is, and it does not give me or you any asset protection. It also doesn't give us any tax savings. It's not going to save income tax just because, or estate tax because we're using a revocable trust. And why is that? Well, if you allow me to use my hands again, here's the revocable trust, and here is the government or Uncle Sam, and over here is you. So let's say that you have a revocable trust. How is it identified? It is identified by your social security number. And remember, prior to having a trust, you had a social security number. After you implement a trust, the trust is identified by your social security number. So Uncle Sam looks through the trust to you as if that trust did not exist, as strange as that may sound. So that means, in a nutshell, your tax filings will not change if you have a fully funded revocable trust. So the cost of a revocable trust versus the cost of administration of a probate estate theoretically is less. And that's because your revocable trust trustee, if that trust is done properly, theoretically does not have to jump through the same hoops as a as a probate plan would. But as we look at the administration of a will, a probate estate, versus the administration of a revocable trust, we find some similarities. Depending on the situation, your trustee of the revocable trust is going to want to walk through some of the same steps, even though it is not under the control of the orphans court or the government. It's a private situation. Your trustee is going to want to be accountable and walk through some of the same or similar steps. So that is something we cover in our trust administration and estate administration workshop. So for those of you who may have the time and the interest to watch that webinar, we're happy to send that to you today as well. So again, as we look to the revocable trust, we see some of the same elements. Here, the revocable trust has become the driving force of the estate plan, not the will. And you'll notice if you look closely, the will has become secondary in the background. There's now a backup will function, whereas the revocable trust has taken over. And that's why one of my first questions to you, those of you who have a revocable trust today, have you funded that trust? And that's one of my first questions. Notice, however, powers of attorney and advance directives, those incapacity planning documents are still extremely important, because what does not go into the revocable trust? Retirement plan assets, 401ks, IRAs, and so forth. So the powers of attorney control that, and the successor trustee in the revocable trust controls your assets if you become incapacitated. So once I've said that, we realize that the revocable trust is not only what happens at death, but also it acts as a living tool. That's why we might refer to it as a revocable living trust. Now I'm getting ready to take just a pause to see if anybody has questions, but before we do that, let's talk about another alternative way to leave assets. And many of you have assets titled this way. Many of you have financial advisors who have your assets titled this way. And we want to be careful here because these are non-probate transfers. So let's just spend just a minute or two on this. Many of you or all of you are familiar with joint ownership. I have a joint ownership of an account with someone. Well, there's no probate. On my death, the surviving joint owner, by operation of law, will take that account. I have a beneficiary designation. Of course, my surviving beneficiary is going to take that life insurance proceeds or take that IRA. I could even leave my property by something called a life estate deed to someone that is kind of similar to leaving a beneficiary designation on a deed, which is not really accurate, but it's similar to that. Transferable on death of a brokerage account. I can have a brokerage account that goes TOD, transferable on death to beneficiaries, or a bank account that's POD, I mentioned that earlier, or an in trust for account, which is similar to having a beneficiary designated account. These all avoid probate. But why do I bring this up? Well, as we look at wills versus trusts, what do we know about either one of these? We know that if they're properly structured, these are going to drive down assets to our loved ones and beneficiaries in the way that we want those assets to go. And we know that these documents provide for contingencies. This is what we're going to do, but if this happens, the document provides for contingent distribution of the assets and other backup provisions. So here, what we have to understand about non-probate transfers is that they do not provide for that same flexibility. So from an attorney's point of view, we want to use these strategically. We want to use them where they are appropriate, but we do not want to use these as a substitute for the estate plan because they do not provide for the same continuity or flexibility. For example, many of our financial advisor friends, they will advise clients to make many brokerage assets transferable on death. So let's just take that as an example. And we now go to the next slide and we see that from the estate planning point of view, we've created a fabulous will or a revocable trust. But let's just go down there about 3 bullet points where it says transferable on death. Now, if this was my will or your will or trust, and let's say that you have specific intentions or specific purposes, and one of those was to definitely control. You were going to control how these assets went down to children or nieces or nephews or even spouses. And you had particular purposes for special needs planning or asset protection planning or whatever that may be. But look at how the assets are titled here. We have transferable on death assets going straight to the beneficiary, even though my trust or my will was really top of the line. My will was the best you could possibly get, but the asset really went straight to the beneficiary, and my intentions were not carried out. My intentions failed. And here is another illustration of this same thing. I have the greatest trust or the greatest will in the world. I've got it perfect, but my assets did not flow properly because of my transferable on death or other non-probate transfers. So putting documents together, designing documents, no matter how good they are, is not going to do us any good if our assets are not properly flowing with the estate plan. And we call that the funding and alignment of assets, which is arguably the most important thing in estate planning. And that is encapsulated in one statement, and then I'm going to take a pause. How do I own my assets at the time of my death? That is really the question. How do I own my assets at the time of death? And is that in coordination, that ownership, is it in coordination with the desires, the intentions, the purposes that I've put into my estate plan that I worked very hard to put in place? Are my assets flowing properly? Okay, Jeff, I'm going to take a break just to see if anybody has any questions. I know that's an awful lot in the first 40 minutes or so, and I'm going to take a sip of water.
Thanks, Steve. We do have a few questions here I'd like to pose to you. A couple of them are jumping the gun a little bit with some info from a little bit later, but I'm going to pose them to you if that's okay.
Perfect.
So first one is, what happens with the cost basis of a stock in a revocable trust upon death?
Thank you for that great question. My answer is that thank goodness Congress has not taken away the step up in basis that was talked about in 2021. And at one time in 1980, I believe, they took away the step up in basis for 1 year, I believe, and then they restored it. So assuming that you have a revocable trust, in your question, at your death, if it is a non-retirement asset, such as a stock, like you mentioned, you will get a step up in basis. You'll get a 100% step up in basis. You should, if you own it yourself. If you own it jointly, you may only get a 50% step up in basis, but Congress has still provided for the cost basis adjustment at death.
Okay, next question. If a grandparent with an estate under the estate tax exemption maximum makes a grandchild a beneficiary of his IRA, is there a generation skipping tax to be paid at the time of the grandparent's death?
Jeff, what was the first part of that question, where the grandparent had more or less?
Under the estate tax exemption maximum.
Yeah, well, that's a very fact-driven question about the state and all that, but my initial reaction is to say that there wouldn't be, because it sounds like they are under the exemption amount. But again, it depends on, whether there are two grandparents still living and this is the first to die and so forth. So it's hard for me to answer that with any accuracy, but I would say the answer is there would not be any generation skipping tax based on that question.
Okay, very good. And one more, and there are a couple of parts to this, so I may need to repeat it. You mentioned IRA beneficiaries. If a child inherits an IRA from a parent under the 10-year rule, during years 1 through 9 after the parent's death, must the child take a distribution? Is the answer affected by whether or not the parent was taking required distributions? And also, is the answer affected by whether the IRA was traditional or Roth?
Yeah, well, the first part of the question I can answer for sure today in the interest of time, and that is that the newest regulations seem to suggest that the child will have to take substantially equal payments over those years. And the second part of the question, Jeff, was?
Is the answer affected by whether or not the parent was taking required distributions? Yes. Or the answer affected by whether the IRA was traditional or Roth?
Yeah, I believe the answer is going to be affected by whether a person was taking minimum distributions. And there's a possibility that if I'm understanding your question, there's a possibility that it will be less than 10 years. There's a little aberration there in the rules, if I recollect properly, and it would be different versus traditional versus Roth.
Okay, and then the last part of that, is there any part of that determined by any life tables associated with the required distributions?
Well, it would be for a person who is taking life distributions for their own, meaning the required minimum distributions for their own IRA during their own lifetime. But for beneficiaries of these IRAs, unless that beneficiary is exempt under the Secure Act, then we're not looking at life tables, generally speaking, because there are 5 exemptions: spouses, minor children, persons who are less than 10 years younger, the chronically ill person, and the disabled person. For those persons, we're using life tables to determine what their minimum distributions are. I believe that's the single life table, and that's where that would come in.
Okay. And another one here, please explain tenants by the entirety. What would happen at death? Is this a common setup?
Yes, thank you for that wonderful question. I'm going to get into a little bit more depth about tenants by the entireties for asset protection, but the answer is simply, for now, is that tenants by the entireties is the marital form of joint ownership, and it would pass to the surviving spouse like a joint ownership. The umbrella of some asset protection exists during the lives of both spouses, and I'll get to that in a future slide here.
Okay, and one more. Does a deed wipe out a will?
Well, if I understand the nature of that question, what I think you're saying is, does a deed supersede a will when it transfers real estate by deed? And the answer would be yes.
Okay, that's everything for now. Thanks very much.
Thank you for all those questions, everyone, and thank you, Jeff. Okay, let's now get into the second half of the presentation, talking about incapacity planning. Now, on a Friday morning, this is a tough subject, but I'm going to prove to you why this is so important. I've had people as elderly or old as 105 years old in my conference room just in the last 18 months. I've had many people over 100 years old, many 101-year-old, many 102-year-olds. I know you know of such individuals. So people are living a long time. Understanding the nuances of incapacity is extremely important. I mentioned that the financial power of attorney is arguably the most important of all estate planning documents from an attorney's point of view. But of course, the advanced medical directive is extremely important. I've been blessed to have chaired Law Day Maryland, where advanced directives are prepared at no charge for many seniors throughout Maryland. And now Lindsay Moss from our firm has been in that role for the Elder Law Section Council of the Maryland Bar. But the issue here is that advanced directives are so important. So I'm not saying they're not, but from a financial side of estate planning, meaning asset preservation, flexibility if we are incapacitated, being able to prescribe in advance. What is my philosophy? These are not just a couple of documents here. What is my philosophy of how much power do I want to give my agent, and what can my agent do for me that I maybe would have done myself if I had the ability to do it? Is it that my agent can establish trust? Can my agent transfer assets away from me to relatives and loved ones? Can my agent do Medicaid planning for me? Can my agent do special needs planning for me? All kinds of questions that we talk about incapacity planning. So when we look at incapacity planning, we're talking about creating flexibility, providing for future instructions. But look here in the middle, my little negative crossed off circle here. We're avoiding guardianship. So the main thrust of incapacity planning is the avoidance of adult guardianship. We know that most of us, our minor children, have grown up, although some of you on this webinar have minor children. And if we do, we're going to provide for provisions for guardians of minor children. Here, as adults, we don't want to ever be under a guardianship. We want our affairs to be handled privately, and we are appointing our agents for financial purposes, our agents for healthcare purposes. And by doing so, and by having family cooperation in addition, we can avoid guardianship of our property and guardianship of our person. Now, you'll notice that one of those circles that I drew there has to do with the Maryland statutory power of attorney. I'm going to let you look at it again. For those of you who are not familiar with this, and many of you are, this came out in 2010 because Maryland's power of attorney laws were not good. They were loose and fast. They were not substantial. And so, to make a long story short, the statutory powers of attorney allow someone who lives in Maryland to have assurance that the power of attorney will actually work when it is called upon. And remember, when that power of attorney is called upon, we are in a crisis. So we want a power of attorney that works. We also want to design additional powers when we're doing estate planning. Now, these powers are not for everyone. There is no one size fits all. One person might want to give very aggressive powers to their agents because of their family situation, while another person might say, my values and my goals do not include these very aggressive powers. So this is an individual case-by-case thing, but I want to just give you, for your own information, the following slides that you can review in your own time that really talk about some of the more advanced powers that one can provide to their agent. And these advanced powers are something that we would normally include unless a client says, no, I do not want to include. And some of these powers are very aggressive. So what we are really doing in basic power of attorney planning is deciding, again, how much flexibility or lack of flexibility do we want to provide, with the idea that in a perfect world, we're going to provide for lots of flexibility for our agents so that they can do the things we could have done ourselves. But again, every situation is different. For example, gifting powers. One person might feel very strongly that gifting powers are fine, while another person may say gifting powers are too aggressive. This is a counseling issue, and this is one of the things that Elville and Associates is known for, which is our education about these particular documents in general and why they are so important. So that said, I'm just going to let you look at these slides in your own time. Powers of attorney can be effective immediately or subject to some event like someone's disability, and they can spring into the future. They also can be stored in different ways where the agent either has access to them or doesn't have access to them, and these are counseling issues. Let's switch now to healthcare decision-making before we get into the latter part of the presentation. Some clients say this is the most important document to them. Now, there are many different versions of advanced directives. There are the 5 wishes. There's the Maryland Attorney General's form that we use and recommend. And why would we recommend that? Well, it has lots of space for what I might call customization. You can customize your advanced directive, and you should. You should think through the issues. Look at some of the bullet points that I've given you here. Most people just either don't fill out one of these forms, or they fill it out and just, really don't take the time, through no fault of their own, to understand the nuances here. Personal preferences, food requirements. We've had clients in hospitals that could not get the food that they needed. That's a special food. When does the power become effective? End of life decisions, flexibility options, organ donation, and final arrangements. So there's no limit to what you can do with an advanced directive. And of course, you do not have to elaborate, but remember, your agent will not know what you want as far as your healthcare wishes other than what you told them during your lifetime. And therefore, we highly recommend that you sit, that you contemplate, and you customize your advanced directive as much as possible. Many of you are familiar with what is called the medical order for life-sustaining treatment, which is required in Maryland. This is an education that I strongly recommend that you give yourself. We do have a webinar that Jeff can send you where there's a portion of that webinar that talks about the MOLST form, but you can go right to the Attorney General's website, marylandattorneygeneral.gov, and really look at Maryland healthcare decision making. What our goal is, because we are not medical or doctors here, medical people or doctors here at our law firm, we strongly recommend you talk to your doctor about MOLST. We strongly recommend you educate yourself and your agents about MOLST, and that you understand that this is a requirement in Maryland. And it does and doesn't have any relationship to the advanced directive, and that's part of the from our perspective, this is part of the education process, and we educate people about MOLST here at Elville and Associates. Jeff, if there's no questions, I'm going to keep going into the tax part and the latter part of the presentation.
Thanks, Steve. Let's see here. We have one question, and it is, what is gifting?
Well, thank you. Gifting means, in our world, gifting to a child or grandchild, for example, and we're going to talk about that here in just a second, but gifting means giving a lifetime gift of cash or other assets to someone else. And the IRS allows, and we might as well get right into that right now, the IRS allows you to give $17,000 per person per year to as many people as you want with no tax ramifications at all. So that is called the annual exclusion from gift tax. But above and beyond the annual exclusion, and I'm not trying to be funny, depending on how much wealth you have or do not have, you can gift up to $12,920,000 with no tax. That's because the estate and gift tax exemption right now on the federal level is that high, $12,920,000. Maryland has no gift tax, so with some considerations ancillary to that, you can gift without any gift tax ramifications in Maryland. But all gifting should involve some kind of counseling to understand the income tax ramifications and so forth of a potential gift. Now, with that said, if you gift more than $17,000, which I am told next year will be $18,000, then Uncle Sam starts to count. Uncle Sam counts how much you're giving if you're giving in any one year more than $17,000 per person per year. However, even if you gift above that amount, if you've never used your $12 million, there is no actual tax. So it's very confusing, but that is the basics on gifting. So with that said, Jeff, I'm going to go into the latter portion now as we wrap up in the next 15 minutes. The current tax environment is extremely favorable as far as the state tax goes. We have a step up in basis, as one of the listeners asked about several months ago. We have this huge $12,920,000 exemption. We have a $5 million Maryland estate tax exemption. So we have a very favorable income tax and estate tax environment to do tax planning. So this remains a constant right now. We are aware that at the end of 2025 and the beginning of 2026, we are supposed to lose these large federal exemptions, which are going to come down to about half the level that they currently are. So we have to be aware of that for those of you who are higher wealth individuals. But for most Americans, there is not going to be any estate tax and very favorable income tax environment if they die, depending on how they leave their assets. So that covers our first two bullet points. Maryland planning is in flux in the sense that what I mean there is that if the federal government lowers its exemptions, to my belief, Maryland will lower their exemptions. That's going to affect many more people than on the federal level, although it will still affect a lot of people. So that's why I say that. Portability still is in existence for those of you who are married. We see no end in sight for this federal rule on portability. What do I mean by that? Well, if a spouse dies, their surviving spouse can choose to use or port their $12,920,000 to themselves and use not only that exemption amount, but that of the surviving spouse as well, whatever that may be at the time of their death. Maryland also has portability, and some states do not have portability on the state level. So we're very lucky that Maryland says between spouses, you can port the deceased spouse's exemption, and you can have 10 million in exemption. So we want to wisely and intelligently use the exemption amounts. Now, when we're doing planning, if you're married, I'm talking to those married individuals or people who are getting married, you can exercise marital control to prevent a surviving spouse from giving the assets to a new spouse. You can protect children and grandchildren through this marital control. Everything is goal driven. Remarriage protection, I just mentioned that. So because of a new law we have in Maryland as of a couple of years ago about the spousal elective share, We now know that surviving spouses have much greater rights. So if you are entering into a marriage or in a marriage where you want to make sure that if you die, your estate can leave assets in a different way, not to your surviving spouse, but in a different way to your children or other beneficiaries. We want to make sure that we have a prenuptial or a postnuptial agreement in place where the survivor does not have the right of election that could thwart your estate plan. So these are things that constantly are developing in the law, and something that we wanted to bring to your attention. In the long-term care context, you may have heard me mention at the beginning of this webinar, what is the difference between elder law and estate planning? And that was the question my young colleague wanted to know yesterday morning during my discussion. And the main difference is that if we think about estate planning, what is it really that we're talking about today? We've talked about process. We've talked about how to leave assets, tangible items, specific gifts, the balance of our estate, IRAs and 401ks, savings bonds, life insurance. How do we leave all that? That's what estate planning is about, and it gets into the tax issues. It gets into the weeds about asset protection and all of these things from the traditional aspect. But as we go down a continuum, if we went from left to right and we go down a continuum towards elder law, we start to get into a different world. We get into a different world where we're planning for disability. We're planning for the divestment of assets to preserve assets, not for conventional reasons, but for long-term care reasons. We might be planning for Social Security, housing, continuing care retirement communities. We might be applying for veterans benefits. We might be applying for lifetime Medicaid benefits that could be community-based, or they could be long-term care skilled nursing-based benefits, or they could be waiver benefits. So all of these things combined into a new field of law where the emphasis is not just on these traditional tax planning and disposition of asset issues, but asset protection for long-term care and all the long-term or Medicaid elder care type issues that diverge or kind of go away from the traditional model. So with that said, what we want to do when we think about elder law is we want to think about flexibility. And that's why, for those of you who really were listening during the power of attorney presentation here just a few minutes ago, that's why those documents are so important. If we're providing for this flexibility for elder care planning as we get older, as we go down the road, that's where that flexibility comes in. So as we start to wrap up, I wanted to make sure I cover asset protection from a three-pronged approach. If I were to just say to you, hey, we're going to talk about asset protection, it would be very confusing because it's a very broad topic. I'm going to go through a few things here, starting with lifetime asset protection, then getting into the long-term care asset protection, and then the asset protection from a conventional point of view that I mentioned earlier that we can do for spouses during our own lifetimes in certain instances, and at death for sure, we can give people asset protection that we love. So let's start with lifetime asset protection. And one of our listeners this morning talked about tenants by the entirety. This is the foundation. So what this slide shows is the lifetime asset protection that we may have now, or that we can absolutely take advantage of now in certain circumstances, that we may not realize that we have, but that we should understand that we have in certain circumstances. So those of you who are married individuals, your spouses, in Maryland, and Delaware is also a big tenants by the entirety state, we have the umbrella of tenants by the entireties. This is the umbrella that says, if I'm married and I get sued, but my spouse does not get sued, that creditor cannot undo my tenants by the entirety property. And that would typically be your residence. But tenants by the entirety can also be applicable to brokerage accounts and other assets. So we want to, from an estate planning point of view, if you are married, we want to utilize tenants by the entireties to the fullest amount because it is an umbrella of asset protection at a basic level. Now, if both spouses get sued, there is no asset protection. So we can't always hang our hat on tenants by the entireties, but it is the start. Life insurance is protected in Maryland from the claims of creditors so long as your spouse or child is the beneficiary. The same is true for annuities. Qualified plans, your qualified plan is protected from the claims of creditors. You cannot lose that in a lawsuit. IRAs are protected in a similar way, but with some further limitations, but generally speaking are protected. However, when we die, and we were talking about this a few minutes ago, leaving assets to our loved ones from an IRA to our beneficiaries, they do not enjoy asset protection in that inherited IRA. So if we want to do that, we want to make sure we leave an IRA into further trust if we want to make sure the beneficiary is going to get that asset protected. Domestic asset protection trusts are trusts similar to a Delaware trust, our neighbors to the east, or a South Dakota or Alaska or Nevada trust, for example. These are trusts that are hybrid if we want them to be, or there are spousal trusts that can be created in these states, and this gives us lifetime protection in certain ways. There is also something called a lifetime marital trust, which I'm not showing you here, that could actually be created if you're married during lifetime and provide your spouse with asset protection, even in Maryland, and this is a very strong way to do asset protection. Now, I want to juxtapose that with asset preservation from the long-term care context. We were just looking at basic asset protection that many of us have, especially if we're married, but we have now this asset protection for long-term care. Elville and Associates is blessed to be one of the leading authorities, we believe, in Maryland on Medicaid asset protection trusts. These are very dynamic tools that are used for asset preservation to divest assets. They're a powerful tool to be able to maintain the cost basis adjustment that this person asked about earlier, and also give the grantor of the trust some limited control, while also protecting the assets from the claims of beneficiaries' creditors once we transfer that to the trust. But what's the purpose of this trust? The purpose is to start the Medicaid look period. Medicaid says if we divest assets, we have to wait for 5 years or 60 months to be able to say that those assets are no longer available to a Medicaid spend down. So that is a powerful tool that we strongly recommend to review. We are not a firm that says all clients should have a Medicaid asset protection trust, but they are a very versatile and powerful tool that should be reviewed. Those of you who are eligible or potentially eligible for veterans benefits, and the Veterans Administration has many pensions, I should say, and the one we're talking about here is the veterans pension called the Aid and Attendance Benefit. The Veterans Trust is a hybrid version of the Medicaid Trust, and it can be used as a powerful tool in that way. Trusts established under wills are a strategy since 1993 for couples that are experiencing where one of the spouses is impaired or has a diminished capacity. This is a powerful strategy of transferring assets and providing certain strategies if one of the spouses dies first, that is the well spouse. This is a strategy that should be explored for elder care under the right circumstances. The augmented estate is a fancy way of saying that when the new Maryland law passed in 2020, giving surviving spouses much more rights, Maryland also compromised, or the legislature compromised, with the elder care attorneys and the estates and trust attorneys in Maryland to basically codify a rule that, to make a long story short, gives advantages to couples who use this strategy that I just described, the will that leaves a trust for a surviving spouse who is ill. Well, this augmented estate strategy codifies the fact that that is going to make sure that if the well spouse dies first, the assets are preserved for the survivor, and the state of Maryland would have no claim to those assets. So among other complexities of that law, this is one of the bright parts of that law for elder care and asset preservation. So we talked about the current 5-year look period. An elder law consultation, for those of you who may ever need it, will describe the difference between these new laws versus the prior laws back from before the Bush era, where we now have different rules for Medicaid asset protection and how we have to deal with those in relation to the 5-year rule. For some people, they do no advanced planning, but through flexibility that is built with powers of attorney, we can preserve assets through a strategy called the rule of halves. So when we're thinking about elder care and elder care planning, even if you've done no advanced planning, but you've built in the proper flexibility and powers into the power of attorney, your loved ones could save approximately half of your remaining assets under most circumstances where there is a single person who survives and now that person has to go into long-term care. Life estate deeds are a simple way to preserve real estate without the use of trusts, but they have drawbacks for long-term care purposes in that they are irrevocable and they don't have any flexibility. But for some people, this can be a powerful tool. And as we start to wrap up, I wanted to talk to you about asset protection at death. So we've talked about asset protection during life, asset protection from long-term care for long-term care purposes. And now I want to end with a few notes here on asset protection at death. Many of us want to plan to protect our spouses from the remarriage possibility, meaning them being taken advantage by a new spouse, or losing money to a new spouse, or protecting our loved ones and other beneficiaries from the potential influence of a new spouse. So we can leave trusts for spouses. We can leave trusts for children. Those children can be protected from divorce and bankruptcy and basic creditor claims. We can protect special needs children. We have a big practice in special needs, and we're very blessed to be of value or service into that area. And we do this kind of asset protection through the structuring of certain features in trusts, spendthrift provisions that protect the beneficiaries. Sometimes beneficiaries can have control, but one of the big questions, and we just did a workshop yesterday with a financial advisory firm on how to select trustees. So many of you who are thinking about this and thinking about trusts in general may want to watch our workshop on how to select trustees. And Jeff has this repertoire of webinars that he can send out if you would like to see that. One of the flexibility tools in the modern world in trust is a trust protector. We want to make sure you're educated about this and know that this tool is available to you. So with that said, I'm going to start to wrap up by just making just a few comments about the Secure Act. We mentioned this. This is one of the reasons why those of you with an estate plan may want to have your estate plan reviewed to see how your estate plan might be affected by President Trump's signing of the Secure Act in 2019, and it became law in 2020, and how the regulations have been updated a couple of times since then and probably will continue to be updated, because this is that thing that causes that 10-year taxation for the majority of beneficiaries. And I articulated the 5 exceptions or exemptions from the Secure Act. And all plans, generally speaking, should be reviewed about the Secure Act to see what should be done, if anything, in those plans, and for parents and grandparents to understand how those IRA distributions are going to be taxed and how that affects the beneficiaries, or if the beneficiary is exempt, how to plan for that exempt beneficiary. Elville and Associates has a client care program. We are one of the only firms in Maryland that has a client care program through the Client Care Academy in Boston, and we are very proud of this. We encourage you to find out about our client care program, not because of anything related to its promotion per se, but because this is the tool for you to be able to have a program that says, I am in partnership with Elville and Associates or any law firm of your choice, and I'm committed to the continuing updating of my plan. So that is what we're illustrating here by showing you that we do have a client care program. The purpose of this is to educate you, continually educate your loved ones, and to educate your fiduciaries. So I will let you see this and know that it is an important part of our practice and of our belief system. Now, as a path forward, someone once said to me, who was a very well-known financial advisor in this area, Steve, Elville and Associates does a great job educating people, but it's also important that people be organized and they have a path forward. So that's what I'm committed to, is to make sure that we're not just educating you, but that we're giving you an opportunity to have your plan reviewed, to find out more about planning and to understand how that works. So we want you, of course, to meet with us. I encourage you to contact Jeff or to contact my assistant, Barbara Rodden or Jasmine Braxton, and to make sure that you have an appointment so that we can meet. We want you to complete an estate planning questionnaire. Yes, we want to put you to work because we want to know more about you, but remember, when you do this, and if you do this, there is nothing to fear because you really have a confidential relationship. Even if you do not move forward as a client with us, you have a confidential relationship, an attorney-client relationship, when you sit with an attorney and share your thoughts, ideas, and information. So we encourage you to bring your documents. Generally speaking, we do not charge to review documents and see what you have and make recommendations. So we're very happy to do that. We want you to prepare questions. We love questions. We thank you for your questions today. It makes it very interesting for everyone. It keeps me on my toes, and it makes for a great webinar. We want you to bring those questions with you. Questions that you may have had for many years, but you have anxiety or have curiosity about these questions. We want to help you resolve those questions. We want you to have a financial advisory and tax team. Those of you who are on the webinar here today may have that already. You may have a financial advisor that you have a lot of confidence in. You may even have an insurance professional and a CPA. We want to make sure that we're collaborating with your advisors. If you don't have a collaborative team, we want to help you form a team. And we also want that team to be communicating with one another. It doesn't do enough good, I should say, to have a team if that team is not comprehensively collaborating and communicating. And that is our goal here at Elville & Associates, is to help you achieve perfection in your estate planning and planning that actually works. And lastly, one of the most important things that we at Elville & Associates believe in and want you to know we want for you is to have the time to actually think. So when you come in, we have technology in all of our conference rooms. We are using the latest leading edge techniques in planning, and we want you to really know that despite all of those things, that this is really a time for you to come, a place to think, a place to receive counseling, and a place to be able to formulate what are my deepest thoughts, intentions, concerns, my goals, and my purpose. So with that said, thank you very much, Jeff. We've got about 10 minutes, and that should be plenty of time for more questions. But again, I thank everyone for their commitment, for helping us put on this webinar, and for being there for us today and being with us. And I'll turn it back to you, Jeff.
Well, thank you, Steve, and thanks for a great presentation, really comprehensive. And I think the last part, finding your purpose. What is our purpose in everything that we do in life? And that includes estate planning. I think that's really important to get down to the basics and then build from there. So thank you very much for that, Steve. So now would be, as Steve mentioned, your time to get those last questions in for Steve. We do have a few here that I'm going to start with, and I'm sure we'll have a few more come in. So we have a question from one of our good clients here, Steve, Mr. Smith. First one is, many continuing care retirement communities and similar contracts call for major, quote, refundable large entry fees. Lots of questions, but too many to address in a seminar. But are there any general comments that can be made about that?
Well, thank you very much for attending and for your question. I'm extrapolating from your question what I think you're asking. I have seen some huge deposits at CCRCs recently. I believe deposits in the Rockville area at a couple of facilities are in the $800,000 or $900,000 range, certainly up to the $500,000 range. And of course, not just exclusive to the Rockville, Bethesda area. I would say this is something that is going to be part of the idea of the continuum of care. The question in my mind is, do we feel comfortable, emotionally and otherwise, do we feel comfortable being at the CCRC, the Continuing Care Retirement Community? And if so, what kind of contract do they have? Now, there's 3 or 4 different kinds of contracts. There are different approaches to the CCRC. So does this particular one, satisfy you emotionally and in your life situation? Because remember, the purpose of the CCRC is to not only provide a high level of amenities, but continuity of care through long-term care. And many facilities will have what I would call a quasi guarantee of continuing care, even if you run out of money, so long as their philanthropy or beneficial fund, whatever they may call it, is funded. So I think this is a broad question of, we don't want to take my $500,000 or $800,000 or $300,000 CCRC deposit and just put it in the hands of the CCRC where it makes no interest and it doesn't work for us over the next several years. Nobody really wants to do that. But do the ancillary benefits of the CCRC justify that? And I think for many people, it does justify that. And I think that you just have to be aware of the contract provisions, be aware of your purposes as you either are at a CCRC or contemplating a CCRC, because it is a different model and it is something that's not for everyone. But at Elville and Associates, we've seen many happy clients that go to CCRCs, and it's an individual thing, and due diligence is the key.
Okay, great answer, thank you. Next question, what's the ballpark figure for setting up a straightforward revocable living trust advance directive power of attorney? Is there a flat rate?
Thank you for that question. Fees are going to vary depending on your needs. It's going to depend on whether you're single or married. It's going to depend on the law firm. And it's also going to depend on whether you have an existing revocable trust that needs to be amended. Many times we amend revocable trusts on an hourly basis instead of a flat fee basis. It's also going to depend on whether or not you wish to protect beneficiaries and how complex it really is. So what we do here is we provide a free initial consultation to really, and that's usually about an hour and 15 minutes to an hour and a half. And then we go over, based on what we find in that consultation and the information you provide, we then kind of match up a fee and see if you want to move forward. But that's where we have to kind of leave that fee discussion, because it literally does depend on the situation. But thank you for asking, and we do disclose fees, and we must disclose fees at the time that we are actually talking about this in a consultation.
Next question, how does long-term care insurance work with a revocable trust?
Wonderful question. Well, a typical long-term care insurance policy, that a traditional policy, is going to stand on its own and really not have anything to do in relation, generally speaking, to the revocable trust. So I congratulate you if you do have long-term care insurance. That will not affect your revocable trust directly, but indirectly, this is going to plug the gap that many people do not have, that nice long-term care policy. No matter what it is, whether it's a smaller policy, larger policy, it's going to plug that gap of potential asset loss due to long-term care, of course, but that's the only relation it really has to your revocable trust, which is to preserve assets in the event that you actually have to trigger the use of that long-term care provision. Now, there's a hybrid long-term care policy, such as MoneyGuard or Pacific Life's products. And I saw a product the other day that had to do with Bright House, And these are different hybrid products that are out there that are more annuity-based products. So depending on what those contracts are, they may have a death benefit similar to an annuity for these unused amounts. That could affect your revocable trust planning in the way that your assets are flowing down through that revocable trust, but this hybrid product over here has a death benefit similar to a life insurance policy or an annuity, and we just have to make sure that whatever that may be, that it's flowing properly.
Okay. Next question, more for me. How do we get access to the previous webinar recordings from Jeff that Steve mentioned? So that's a great question. So if you're new to our webinar series, briefly, I always send out a comprehensive message afterwards that includes a lot of information from the presentations that Steve alluded to. That's going to include the links that Steve mentioned, in this case, the Estate and Trust Administration webinar, the trustee selection webinar, and today's video recording. I'll also include the YouTube channel that Elville and Associates has that many people know about and a lot of people don't know about. And that includes all of our webinar recordings from several years and in the past. So you'll have access to everything we've ever recorded, and you can peruse that at your leisure. So great question, and I'll have links to that a little bit later today. Next question for Steve is, it looks like the person just left, but I'm going to pose it because that's a good question for other people. My spouse was not willing to sit in. What is a good way to help overcome reluctances?
Well, that is such a great question. I have actually experienced this many times in my career where I am dealing with a one spouse who is willing to come and is concerned about the planning, but the other spouse is not as motivated. And this is never an easy answer, and I don't mean it to sound like an easy answer, but my answer would be for that spouse who is interested to go ahead and forge ahead with the planning and to be the bearer of the information and be the bearer of the momentum in the planning. And my experience, although I'd have to think about each individual case, my experience is that that spouse either accomplishes his or her planning themselves and the other spouse never participates, which is better than nothing, and it gives the spouse that did the planning assurance and peace of mind. But many times the spouse who was not necessarily interested will come along for the ride and eventually get on board with the planning. So that is what I would recommend. Start the momentum, keep educating yourself, do your planning yourself, and it may not be easy, but your spouse may come along.
Okay, thank you. We have a couple more here. If your last parent passes, leaving 2 adult children and 2 grandchildren for a deceased son, but she never took the son off of a deed, who receives the deceased son's share of assets?
Well, thank you for that.
Land.
I think that's more of a really fine fact-driven question. So
yeah,
you would have to answer that more in a setting of a attorney-client relationship. So thank you for that. I just wouldn't be able to answer that with any sensibility today. Thank you.
Okay. And probably along those same lines, I think we alluded to this question before. If you could clarify that a deed wipes out everything stated in a will, not just real estate. Any further thoughts about that before we end?
That last comment kind of throws me off. So I guess my prior comment was under the assumption that the question is, well, if a will were to dispose of a property, like a real property, real estate, but that property was actually disposed of by way of a deed at death, meaning a life estate deed, for example, then the life estate deed would trump or supersede the will. But when you added other property there at the end, that really kind of threw me off. So a deed would not control other types of property; it would only control real property. So would have to know more about that particular situation. So I hope that helps.
Okay, thank you. All right, well, we're going to wrap up here as we move forward with our Elville webinar series. Well, we actually have one more here. That's a good question. So let's obviously get to it here. I have a special needs adult. Do I start with estate planning or special needs will or whatever, she says.
Thank you for that wonderful question. Very briefly, because I know everyone's anxious to get off the webinar. The answer to your question is that your special needs planning will be encompassed within your basic estate planning for yourself. So that's the way I would look at it, is your planning for you actually benefits your child with disabilities. And as part of your own planning, including your incapacity planning, you would encompass your special needs planning inside of that. So it's kind of all one and the same. So I hope that helps, and we look forward to helping you there.
Sure. And along those lines, next Friday, we'll be talking about what families need to know about planning for a loved one with special needs with Steve at 10. Wednesday, the 16th, we'll be having Lindsay Moss, our senior principal, talking about VA aid and attendance at 10:30, Wednesday, the 16th. And then lastly, Wednesday, the 23rd, Steve will be back to talk about estate planning for surviving spouses, considerations, recommendations, and procedures. So look for the follow-up email from me. And as always, thanks for being part of the Elville webinar series. Have a really great weekend. We'll see you again soon.
Thank you.